What is the order which you have not complied?
Milord, in all the forum, Milord, the state has lost, Milord. And Milord, I have instruction to pray before your
No,
lordship.
which is the order?
Annexure 1.
Annexure?
1.
Huh? Have you included it in a provisional merit list?
Milord, it is already finalized, Milord. And this morning I received the instruction, Milord. It is pending for approval of the Honorable
Where is
Minister.
your affidavit, sir? This is a contempt.
Yes, Milord.
Kindly visualize it.
Milord,
File your affidavit.
Milord, we have already filed it. It has not come with the record. We have already filed it. E-filed it. Already filed.
What?
The affidavit through electronic filing, Milord.
Where is that affidavit?
That has
It's
not
not
come
there
with
on
the record.
record.
I have not been served with a copy. If your lordship can
I
have
will-
a glance at the last order,
I have seen.
my lords.
They given alleged contemnor to explain their conduct in securing the implementation. We have seen. That's why we wanted an affidavit to come.
Your lordship.
Yes.
Is there? Or not on record?
Milord, 19/3/2026. It has not come.
Huh? Today or yesterday?
Yesterday. But
Yes,
Milord,
sir.
I have received instruction, Milord. It is already finalized.
Sir, this is a
Yes,
contempt.
Milord.
Instruction will not do.
That's it.
Pursuant to the order dated
Yes, Milord. Milord. The physical copy I will file today, Milord.
what else?
Pray for next week, the next listing.
Next week is not possible.
The next listing, as your lordship pleases. Item number 2.
Yes, sir.
I'm the party in person.
Why you wanted a review of the order, sir?
Sir.
Not our view, not my view, our view. Tell us.
Other matter. Lord's kind permission, I would like to submit, Milord. Already I have filed a written note that is not been marked as flagged. Here, Milord, once the resolution plan is, Milord, approved by the NCLT under section 31.
Plan.
Resolution plan.
Under the IBC.
My lord.
Then
And whatever, Milord, the dues pertaining to the claim, it's not filed within the, Milord, the plan with the RP was inviting the, Milord, the corporate Milord, claims. And that stands extinguished. Milord, the Honorable Coordinated Bench, or while Milord adjudicating the matter, when the award was passed in favor of a Milord workman in way back 99. Milord, that was challenged before this Honorable Court, and 2019, it was upheld by this Honorable Court. And Milord, the petitioner company, Milord, went under corporate insolvency. This process was started in 2017. And 2017, 2020, my lord, it was
It was under the
Approved.
moratorium. There
My
was a
lord, my lord.
moratorium period.
grateful, my lord. 20, my lord, it is, my lord, approved by the NCLAT,
COC approved, the
Well.
resolution professional was appointed.
my lord.
There
All
was approval
procedures.
of the COC.
And it
But
has went
now the resolution plan is approved by
Approved.
the NCLT. Now
and it
we
was
got it.
challenged by
Go
the
further.
Yes, so in Supreme Court also it has been stamped by the Honorable Supreme Court. My lord, the mistaken and my lord, the assumption of the fact was made when my lord, the Honorable Court my lord, adjudicating para 20 my lord, they said that the corporate debtor had the my lord, occasion to inform the award which was passed way back 99 is called as the admitted workman dues, and it could have been informed by the corporate debtor to the registered professional, and the registered professional
Because the logic of the claim is the very important facet of the.
that was not there.
So,
The claim was not filed. The claim was not filed.
but order of preference. That's not a case of a liquidation.
No,
It
no,
was not a case of a
no,
liquidation.
no, insolvency. And Millard, all the claim, Millard, see, the claim where the admitted workman dues is the resolution plan, which have this entity, resolution plan, there is nil. It is specifically mentioned that there is nil workman dues or whatever these in respect to the workman or the resolution plan, page 66, you'll also may kindly see.
Sir, you are in review. Tell me what is the error? Tell
Error.
me, sir.
Millard, the IBC, it has a Millard separate application, but the Honorable Court directed to accept to pay the claim which was not filed during this Millard period. It stands extinguished.
I do not know if that is there. That may be, I would say, the wrong judgment, but that does not mean
It's the erroneous
erroneous
assumption.
judgment. I do
Is
not
it-
know whether the materials were
Yes.
there, whether those were
Everything
brought
is
to
there.
the notice of the court. If
Everything.
the court has interpreted it,
Yes. Millard,
then interpretation may not be proper. Go there.
you'll also may kindly see the Ghansya Misra case as well as a recent case law, you'll also may
Limitation has intervened there. Against the parent order, the limitation has intervened.
Yes.
So, review is
Filed
is
within,
another lease of life.
no, let's say 2023 judgment review is filed in 2023.
You
and Millard, the petitioner's
go
case.
there.
Millard, petitioner's case.
If the Supreme Court has declined to interfere with the resolution plan, I do not know what is that.
That means the resolution plan
Plan
is
is approved.
appealed.
Appelled.
And Miller,
You'll also may kindly see page annexure 5. The
So I
Millard,
do
the,
not know whether this resolution plan was produced before the court.
Yeah.
Or
yes, that is
we
there.
do not know.
You'll also may kindly see annexure
Someone has
5,
taken
page
it.
151.
yes.
Who is the other side?
Yes, sir.
On the subject
Millard,
that once a decree is passed by the court and the decree is affirmed and has not been assailed, because a resolution plan has been approved, the decree will be a mere piece of paper, has no enforceability.
You also kindly see the statute
Was-
claim definition 3.3.6.
Give the
Malad.
IBC.
Yes, 3.6. And 3.8. Let's kindly.
Kindly give us a moment.
Very interesting. I was not there. Since you were arguing in a very, I would say, intelligently, I was also carried away and swayed by certain things. But I am really thankful to my brother who has taken me to the various portion of the judgments. You were harping all along that this particular claim is outside the resolution plan because everything is nil. But it is a positive finding of the court that it comes within the peripheral of the resolution approved by the NCLT.
No.
No, sir. Why I say what has been held there? It says that there was a quotation from the resolution plan, that is clause 3 at page 61, which says very interestingly, other than the admitted workmen's
Yes.
and employees' dues and potential workmen dues, other than started, and then say any or all claim or a demand, whatever or is of a nature, shall cease to exist and will be effaced and be declared as nil. No problem. So there is an exception which is already created in the resolution. Then the paragraph 16 of the judgment, they wanted to interpret that what should be the meaning assigned to this expression other than the admitted workmanship. It says that prior to the company going before the NCLT, there was already an award passed by the Industrial Dispute Tribunal in relation to the same. Resolution plan also talks about these. So once a decree is or award is passed by a competent forum relating to the workmen, then in absence of any further challenge, this will become an admitted workman dues. Once it becomes an admitted workman, then in that event it comes within the purview. This is really an interpretation of a particular clause in a particular manner. Now you wanted to say that this interpretation is wrong.
My lord, kind permission.
Sir, you are saying that this interpretation is wrong.
My lord.
Correct?
My lord.
It may be a wrong decision, erroneous decision. Again, I am reminding you what I said. But it can't be said to be. Sir, if there are two ways of looking into a particular thing, then in that way, if one has been adopted, may not be correct, but you'll have to go higher up. You can't seek for.
My lord, kind permission.
Sorry.
My note may kindly see
Sorry.
page 6.
Whatever.
Page 6.
Whatever.
Page 6.
You
I'm a
just told
particular
me
place.
the law is well settled.
I'm a particular place. What is the admitted workman dues?
Apart from permitting use, you must also kindly permit this. The lordship was referring to that, you are not looking at the page. And you look at that page of your plan.
Yes. My lord, kindly see page 6 of my note. I have also conscious about my lord's finding.
Sure.
And what is potential workman, what is admitted use?
No, we are not going into the interpretation, sir. That is what we are saying.
Not interpretation.
Please show us paragraph 6.
Page 6, para C, ground of review.
Where,
what my lord was
petition or what?
Written note.
Where is the written note?
Already filed, my lord. That is review petition.
Where flag?
Its flag is not numbered, but it is reflecting in the
Cause list. It is filed in this.
That's the first ground we have taken in the ground of review.
It is kept on the top of
Para C.
Top of the record. Okay. Oh, written notes.
My written notes, ground
Para C.
page 6, para C.
Page 6.
Para 16 of the judgment.
Sir, again, that's why I'm saying, sir, you are not understanding. I appreciate. You wanted to say that the interpretation which is assigned by the learned judge for the expression admitted workman's due is erroneous, not correct. That makes the judgment erroneous. You want, I can give you a multiple judgment which says a distinction has to be drawn between an erroneous judgment and a judgment containing an error apparent on the face of the record. I think AIR 1967 or 8, Tungabhadra's judgment is the first judgment which I always embrace. Deciding the jurisdiction of a review. Have you got that judgment of Tungabhadra? Can you find out?
When you are putting your resolution, that don't change the words also.
No, my lord, resolution plan was prepared. No, my lord, resolution plan, my lord, even
Read the law first, sir. Read the law. Have you got the judgment of the
Tungabhadra,
review? Have you brought those line of judgments relating to review?
review I have,
Please.
Tungabhadra is not there.
Yes,
I have,
please, that is the first. Have you brought
I am
my
relying, my lord.
Have you brought my judgments at another high court on the review?
Yes, we have.
Have you got that Tungabhadra? Tungabhadra or
My lord,
Tungabhadra?
permission areas clarified. My lord's permission from my learned senior and your lordship's my lord's permission, if I may kindly assist your lordship.
You assist me on law, don't assist
Yes,
me on
on that.
Clearly, I mean, so succinctly accepted your point. And the initial remark that you do so well, maybe in a intelligent manner. So I think no more you should realize that so clearly Lordship said that yes, your point is taken, but whether it should amount to error apparent or
It is,
erroneous, so
it is an erroneous assumption of fact.
No.
And
That's
that's
a no. That's a coinage of the word, but it does not disturb the I would say fundamental fabric. Mr. Acharya, we appreciate the juggleries of the words and the coinage of the expressions, but still it remains an erroneous judgment.
With your lordship's permission.
Yes, where is the
grounds of review is the ground for SL.
have you got that?
Let's make this.
You should have been careful. Maybe you are after drafting SL, you have drafted the review.
No,
You should not have, because it shows that how mistakenly you can take a ground on the face of it. So what is the ground for review page para 16?
My lord.
So that is a clear case what my lord is saying.
Yes, that is what with your lordship's permission, I'll just clarify. I just need Muller's 1 minute, not more than that.
This is what we want to give an interpretation.
Take just a minute.
You should not have used the word except. The word used is other than.
Yeah,
So other than actually the division may say, as it fell from my head, other than. So this comes within that.
May I just take 1 minute of your lordship's precious time? Let's only think. Lordship. Your lordships, what I have mentioned at para C, I'm just reading out. I'm not taking your lordship's time further. That para C of that ground for review, para 16 of the judgment. Para 16 of the judgment has referred to subclause 3. Means that where the admitted workmen and employees dues and potential workmen dues is defined.
Yes, I'm reading. Don't worry. It's defined. Yes, I understood.
I'm just reading. If your lordship will take page 67 of the resolution.
Yes.
Of the brief minutes.
Yes.
Now let's have page 67.
Yes.
Your lordship will see.
But if you may not do the review brief of the
Review brief.
Yes.
My lords have referred to clause 3, Roman 3. Other than the admitted workmen, my lords will see the admitted workmen is capitalized. Admitted workmen and employees dues and potential workmen dues. This entire thing is capitalized. Any and all claims or demands.
They will cease to exist. No problem.
So other than. Now, Millard, whether I come within that admitted, Millard, why
that is what is an interpretation.
It's not.
Is an interpretation.
Just
what it
one
is,
page before
what
your
it says that admitted workmen and employee dues Now, what it talks about, the court has interpreted that once the
Decree
Industrial
under
Dispute
final
Tribunal
dispute is admitted.
has published an award, this award, Industrial Tribunal is always exercising the jurisdiction, which I understood is the intention is exercises the jurisdiction when there appears to be a dispute between a workman and the employer. Once the Industrial Tribunal has passed an award, means it admits the workman as a workman.
What
That
has
is
happened, Milad?
what
The
that
phrase
is.
make
And
this-
once it is a workman, then workman and employee dues means it becomes a due.
No.
So
Milad,
that is what is a wrong, maybe a wrong interpretation.
Yes.
But go higher,
Milad,
not review. Again, I am saying maybe a
not been
wrong interpretation. Go higher.
I have not been able to,
Go higher.
I have not been able to complete my Milad, submission, Milad, in this.
You have to be completed. You have completed twice. So, Mr. Twice, you have to
Right.
ask twice.
Definition.
We admit, sorry, we appreciate what you are trying to say, but still I'm saying we have to just, had it been a normal jurisdiction, what you are saying may be a worth consideration.
That has to be filed.
But review,
That
no sir.
Whatever is mentioned in that clause, that is defined in the plan itself.
plan itself.
Kindly see below the previous page.
Actually, you are not getting it. You have argued so well, so two sides, and the point is that after the challenge that our
I bow down.
confront by no, you didn't listen. Only thing like Mr. is not listening, so you don't adapt.
No, Milad, that is, I can't dare to. I,
Then
my
you
lord,
file
always.
the application. With application gets dismissed. Then you file a review and it kept pending. So that is the
Milad,
I-
my submission, my
What he's trying to say, he's trying to take us to B. What?
B1.
He said, he's trying. He says that the admitted workman and employees dues is quantified or defined, which is outstanding or claimed by the employee and a workman in the list of the creditors dated such and such.
Yes.
But second sentence is the admitted workman and employee dues, if any, shall be treated pari passu with the financial creditor and shall be paid in this. He wanted to say that it will be restricted to the list of the creditors.
Yes.
dated
The
28th
resolution
of
professional should have
2000
admitted.
and not beyond it. Maybe another way of interpretation, but still.
It is
and
what Milad has missed out. Perhaps
Go there.
with great respect.
then suppose you file a SLP and SLP is dismissed also. Still that argument will be open for you. B1. B1 was just now my lord said that suppose even a SLP that because it is not claimed or it is not taken given to the workman because not complying the award is at your option.
Milad, that aspect, para 20. Para 20, you Lordship, may kindly see.
So interrupting.
Sorry, I am not interested.
Sir, then you have not read the judgment, and this is a judgment of a Tungabhadra is by 1, 2, 3 judge bench of the Supreme Court, reported in EIR 1964 Supreme Court, page 1372. There in paragraph 11 of the judgment, what I have dictated is vividly discussed. I am giving you what you are arguing can also be taken into consideration here. It says that what, however, we are concerned with, whether the statement in the order of September 1959 that the case did not involve any substantial question of law is an error apparent on the face of the record. The fact that on an earlier occasion the court held on an identical state of facts that a substantial question of law raised would not per se be conclusive. Then the court, for earlier order itself might be erroneous. For the earlier order itself, similarly, even if the statement was wrong, it would not follow that it was an error apparent on the face of the record. For there is a distinction which is real, though it might not always be capable of exposition, between a mere erroneous decision and a decision which could be characterized as vitiated by error apparent. A review is by no means an appeal in disguise. whereby an erroneous decision, again I'm saying, is reheard and corrected, but lies only for patent error. We do not consider that this furnishes a suitable occasion for dealing with this difference exhaustively or in any great details, but it would suffice for us to say where, without any elaborate argument, one could point to the error and says here is a substantial point of law which stares one in the face, and there could reasonably be no two opinions entertained about it. A clear case of an error apparent on the record would have been made out. I have been breaking my head before both of you that it may be, if there is a possibility of more than one interpretation, if one is adopted, may not be so good, other is more better. That does not mean it is an error apparent on the face of the record. It may be an erroneous decision. Read this chart. Is a three-judge bench decision of the Supreme Court. We are bound by.
We just pulled it out.
And it has not been touched even today. Paragraph 11. So read. So it's a three-judge bench. I am reminding you.
I'll go through it.
I know there are one or two judgments of a two-judge bench.
I'm grateful, my lord. I'll go through that judgment.
But what is the law? If it's a larger quorum, then no, sir. I think it is a.
We'll go
through this judgment.
What go through, sir? Every time when we discuss law, and then you say, I want
In
attack.
that is court.
No, sir,
that
because-
aspect we'll examine. No, we'll come back. We'll come back.
No,
You'll ask me.
Follow up of Tungabhadra mill. Maybe examine and come back.
Yes.
nothing. It was told to you on the earlier application.
This is heard for the first time.
No,
It was heard for the first time, Lord. This matter is first time.
Heard for the first time.
We'll come prepared with
And
erroneous and
Millet
wrong assumptions.
has pointed out by my
Grateful.
Lord Millet that two judgment.
I know. That's why I reminded you of that.
Yes, Millet.
That you will come. Two judgments are. I am my little knowledge. I know, but those are of two judge bench, and this is a three judge bench.
Please
Then which one will prevail?
let us Millet examine this
I will come.
follow up of this Tungabhadra Millet. Let's go.
And then there is a constitution bench decision, that is an Ashok Rupa Hura
Ashok, which
Yes.
laid down the curative petition.
curative review jurisdiction. How far the court
Rupa
will
Ashok.
consider.
It was based on.
There are two judgments of Rupa Hura. No, the second one.
Second. Here, Millet, the only issue is that
I understood. I told you this is what B you are referring, and then you are referring this. Understood, but interpretation is different. No,
let's maybe examine this follow up of
you will examine nothing more than that.
These judgments are there in BCCI versus Netaji and Green Beauty.
The BCCI is a judgment by Justice S.B. Sinha,
Millet.
where there is the other issues where there were certain submissions which was advanced before the court that there exists this particular fact. And this is what is intended by the BCCI and understood by the BCCI. On that basis, the order was passed. But later on, it appears that that submission which was made before the court was not factually correct. Because the BCCI interpreted in a different manner, it was brought to the notice of the bench that, look, this judgment needs interference under the review jurisdiction. Then the question arose that whether the review can be can be entertained on the basis of a subsequent event.
Well, we will come back to preparation next.
Subsequent event was the important aspect there, because it happens subsequent to the order, which is not encompasses within Order 47 Rule 1.
Subsequent event.
No, it does not.
No.
It says on
Cannot.
the date of the judgment that discovery of new and important document must exist on the date of the judgment or prior thereto, not subsequently. Relying on a ILR judgment, if I am not wrong, the bench says no, we can go into and take into consideration subsequent event as well. But that is opposed to the earlier judgment of the Supreme.
We are grateful, my lords. But that part we have not gone through. We'll examine and come back. But I was in a preparation once. In my case also,
You'll also kindly see last order dated 13 February 2026.
Yes, what has happened?
Millards, in this case, the state had preferred an SLP that has been dismissed.
Yes, my
recently,
lord.
Millards.
This is the order, my lord.
It has been dismissed on 12th of this month. So, Millards, some time may be given to comply, Millards.
You file your affidavit.
Yes, Millards.
It appears that
Well, I am told your lordships already previously heard this matter. And
Heard this matter?
yes,
Must have
no,
put
because
a very difficult portion to you.
no.
Huh?
Already because
Oh, yes.
yeah.
Who is the counsel?
Well, I was the council member before the previous division bench.
Okay.
Well,
What is the error committed by my sister?
Well, one thing, Madam, there was two advertisements. My appointment was against the first advertisement. And against the common judgment, Madam, the Honorable Single Judge has not referred to that. That issue has not referred. That's why, Madam, the Honorable Single Judge has in fact, Madam, recalled the entire common judgment, but confine it to the review applications, those who have been filed there. And Madam, the present writ appellant, Madam, was the serial number 1 in the common judgment. And by that time, Madam, the writ appeal was filed. Otherwise, Madam, he would have filed that review application.
The judgment is delivered in WA 552,
Well,
filed by you.
yes, sir.
Filed by you.
Yes.
And then simply affirming the judgment of the single bench. The
Right.
division bench affirmed the judgment of the single
Right,
bench.
right.
That means your writ petition might have been dismissed and the judgment is affirmed.
Yes.
So
But
what is
the ground I have taken, my lord, in the writ appeal was not taken into account. And why I am saying, my lord, the honorable single judge has also, my lord, recalling the order, has accepted that he has not taken up that issue, whether the appointment was in terms of the first advertisement or the second advertisement.
whatever he
Well,
says that he came to a positive finding that your appointment to the post was not in relation to this 1,500 or 15,682 posts.
well, that is, my lord, the additional post which was created subsequently.
Pursuant to any advertisement for those posts.
No, my appointment was pursuant.
There was no advertisement for the post of 15,682. And that's why the court held that your appointment was under that, which was never advertised. So you cannot.
No, that is factual. That's factual error.
No.
First,
So is that incorrect?
that is incorrect. My appointment was in terms of the first advertisement, which was below.
Exactly, first advertisement, but subsequently you were appointed against those posts.
No. That is factually incorrect.
Okay.
That is factually incorrect. Which was subsequently found by the honorable single judge itself, madam. That it was factually incorrect. Subsequent advertisement was issued, madam. If you also look at the subsequent advertisement, the provisional list was published, madam, in December 2004. And my appointment was in February. February, first advertisement was at 25/3/2003. Well, kindly just come to writ appeal matters at annexure 1, page 15 and 16. Madam. The first advertisement was 25/3/2003. I was appointed, madam, against ST male. And annexure 2, madam, the second advertisement, which was subsequently the selection was passed, that provisional list was issued, madam, on 10/12/2004. Madam, kindly come to page 20.
Where is that advertisement?
Advertisement, first advertisement, annexed to page 15.
First we have seen. Subsequent.
Subsequent advertisement was, that is, madam, my appointment is, if you also look at page 17, madam, 10/2/2004.
Yes.
Then, madam, kindly come to the
Where is the advertisement?
annexure 3, madam.
Yes, but where is that second advertisement?
Advertisement, madam, that is not annexed, madam, to the writ appeal. But the fact remains, madam, if you also want one, I will produce that. If you also look at that page, annexure 3, madam. Annexure 3, my lord, is the subsequent advertisement provisional selection list. My lord, see the date. That is 10/12/2004. Where, my lord, my name was there at serial number 47, page 19, as in-service candidate. Serial number 47. Dasarthi Hemram, bracket in service.
Yes, that is because pursuant to the first advertisement, you are saying you had been selected.
Yes. And upon
Is there any reference to that second advertisement anywhere?
Well, that was our case, my lord, in the in the council also they have accepted that position.
Mr. Tripathi, is there any reference to the second advertisement somewhere?
Second advertisement, my lord, in the judgment, my lord, the second advertisement was reflected too.
Yes.
In the judgment, my lord, that starts from page 35.
No, not page. Please point out the paragraph.
Well, paragraph 4, my lord.
Yes.
That is my selection appointment was given 10/2/2004. Then, my lord, subsequent advertisement that has been referred to para 5. That government circular which was quashed, my lord, your lordship will get at page 6, para 6.
Reference in paragraph 5.
Your lordship will see para 7, my lord.
Oh. What are you talking about? So the question is, there was an advertisement for a different post
Well,
way back in the year 2020, 2003.
Yes.
25/3/2003.
Yes.
It says that so far as the scheduled caste or scheduled tribe male candidates are concerned, there were certain posts which were earmarked.
Well,
There were less number of the trained candidates which were found. They were accommodated, leaving a 34 posts remain filled,
Yes.
unfilled. Then there was a circular that you can proceed since the validity of the panel which is prepared is a 1 year, so you can proceed on the basis. But in the meantime, there was another circular which was on 26/9/2003,
well,
issued by I think the collector.
well,
The collector says that whatever the list of 15,800 or 600, whatever the candidates which was prepared pursuant to that advertisement of 25/3/2003, you give the appointments.
well,
Admittedly, your appointment was in the year 2004.
well,
That is after the collectors that the list
Well,
order.
yes.
The collector's order.
well.
That order was challenged.
No, that was not challenged.
Sir, that collector's order was challenged, and the court ultimately quashed that order. The moment the order of the collector dated 25/6 or 26/9/2003
Well,
goes, that means all the appointments which were made pursuant to that 26/9 that has to go. So there was a decision to advertise that 15,600 or 800, whatever the post, again by taking 682 posts to be advertised. The court, after taking into consideration, since your appointment was in 2004, you were not initially appointed prior to that 26/9/2003.
But
The court held that your appointment is within that 15,682. Since that, in pursuant to that order of the collector, since that order is quashed, so you do not acquire any right. Any right. You are saying, no, 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 I was appointed against those posts which were there under the advertisement of 25/3/2003, because there were unfilled posts of 34, that 34 in number.
Your lordship is correct. But that was not of collector, my lord. It was
Okay,
the
circular of the government which has
Yes,
been
sir.
quashed.
that was quashed.
Yes.
From your petition I was reading,
Well,
you have said collector. Whatever he has said.
That has been quashed, so the subsequent letter of the collector also goes.
but by that time, my lord, the appointment was
Goes.
made.
2004.
But 2004,
Sorry.
but
But you are saying that it was pursuant to that particular list. And the court has said that there was no waiting list candidates which were there. Nothing.
no,
And
collector has
the court has come to the
collector has indicated that the selection process has not yet over.
Oh, you can't re-argue the matter. This is a review jurisdiction.
But only one aspect. The Honorable Single Judge found my lord, in the review application that part is not correct factually. The appointment was in terms of the first advertisement.
But the division bench, if he takes another view, then the division bench or the order is the final order.
No, the division bench has not considered that
Sir,
aspect.
there are decisions which says that a appellate court may concur with the ultimate conclusion of the single bench, but may record its independent finding.
Yes.
And if the finding is contrary to the finding of the single bench, then the single bench finding gets merged with the finding of the appellate court. So don't go by the single bench. What the division bench has held, that is what is a final conclusion.
But the Honorable Division Bench panel has not considered the particular aspect.
No, it has very categorically said that your appointment is under that 15,682.
That is factual. Well, my
That's maybe you can't.
well, if lordship kindly permit me, my lord, to the same government counter.
Yes. Will you write or huh? Send it to the sister, pass the order. Yes.
But the government counter, my
Item
lord,
number 2.
the government counter, my lord, accepted that position.
What?
For one.
Pardon, my lord. Item 2, my Item 2, my lord. The middle memo already filed, my lord, permitted.
Yes, please. Let it be called.
Item 1.
I was directed to serve a copy of the writ petition to my long friend Mr. Pai.
Petition or review petition?
Review petition. May I pray? I am not feeling too. Since 2 days I am suffering from fever, cough, and cold. Any other day, your lordship will While traveling in the train, the deceased was a bona fide ticket holder. Instead of coming to the bathroom, did not return. The co-travelers, they
But you approve the RCB, you never produce any material.
made Annexure 1. I deposed also before the RTC.
Claims tribunal.
Annexure 1 at page 9 of the review petition. And she had explained everything in her evidence.
Career. She suffered a massive career for your family. What was the review there? At the station platform, Vijayanagar, they have provided medical assistance.
The Titti was informed by the family members. Titti ticket collector was informed by her medical aid. No medical aid has been provided, for which the deceased passed his life. And she was cross-examined also. But in the writ petition, this honorable court, my lord may see paragraph 1. The petitioner failed to adduce evidence to
by the respondents in the OA. We have submitted, my lord. He was a very he was in a very critical condition while he was moving to care hospital Visakhapatnam, my lords. My lords.
Review.
Yes.
First paragraph
Yes.
shows that the report does not reveal that they produced any evidence to support their claim. The railway claim starts. But the next annexure 1 is told that yes, evidence was adduced.
My
The
lords.
past paragraph, the order itself, there is error and apparent.
Yes. My lords.
This is what is the other current of the legal record.
My lords.
So
May-
My lords is appearing to VC.
Party,
Mr.
May I submit, my lord, one thing? May I submit?
number 27. Paragraph 1, you read of the order dated 7/12 and read annexure 1. Do you support?
Yes, Mr. Padhi.
Yes, what I'm submitting,
Honorable Chief
if
Justice or
they are
not?
coming claim,
Huh.
then let them go and approve the RCT and
No,
because
sir.
alternative quorum is RCT, reading the evidence, all these
So
things.
here we are on the review petition itself.
Yes, because read was dismissed, that's why it's
for
filed for review.
Mr. Paddy, for review, he has made out a ground that there is an error apparent on the face of the record that is in the first paragraph itself. So this review is bound to be allowed. Thereafter, we will decide on merits. Whatever.
Then Lordship will fix it some other day.
What? This is apparent.
Apparent
From
on the face of
annexure 1. Yes, that's a certified copy he has given. And the certified copy shows that as a first witness, the petitioner herself deposed. Then the entire basis of the order in paragraph 1 goes.
Look at annexure 1 to the review petition. That is the evidence recorded.
And that's
Annexure
why I'm
1 to
saying,
the
my
review
lord, in a read jurisdiction, if this compensation will be determined, then other forum will be ignored. So once a forum is available.
No, I understand. But today we are taking up a review application. Whether the writ will be allowed or not allowed, unless we recall the order, then the question will arise.
Then the writ will be heard on merit.
On that point, Lordship may consider. Yes.
We are not allowing the writ petition.
Lordship may consider anything.
Lekhandu, hard learning counsel for the review petitioner as well as
Obliged, my
Obliged.
Item number 2.
May I please, Lordship? Lordship, item number 2 already Udal memo already filed.
Want to withdraw?
Yes, ma'am.
have you filed memo?
Yes, ma'am.
File a memo.
Already memo filed.
A memo file.
Yes.
Obliged, ma'am.
Item number 3.
Restoration.
Application for restoration. Only
It was dismissed for default.
Dismissed for default.
When?
Strike period.
When?
21, my lords.
What?
December 21.
There is order of dismissal for default.
My lords.
Page?
Page 8, my lords.
Annexure 1, page 8.
Added page 10, my lord.
Dismissed for non-prosecution.
Okay. So when you took out an application?
This same appeal was filed when?
25, my lords. There is a delay.
25.
What you were doing for so long period,
Lords,
5 years, 4 years?
I've given some explanation, but there is a delay of 1385 days.
True, that is what I'm asking.
Your Lordship may
What
impose
you
some
were doing,
cost.
sir?
Impose some cost, and because I have a merit. Impose some cost.
My
What
lords,
impose some cost?
Any cost.
What cost? Why?
My lords, my lawyer did not inform me. I've specifically taken
Where is the application and which flat?
Dispense with filing.
My lords, your Lordship will see.
Your condonation of delay application is IA 508.
Yes, ma'am.
Yes, 508, Section 5 Limitation Act. Where you have taken the ground? Which para?
Para 3, my lords.
There is a delay of approximately 1385 days in presenting the petition.
The delay is neither deliberate. The advocate who was appearing in the written did not inform the same. In the year 2002, the petitioner came to know that the application was dismissed for non-prosecution. The petitioner tried to contact his parents.
Condonation is there. IA number 508. I is there.
my lords, I beg apologies.
Oh, this is flagging. What?
But the two IAs, one for dispensing it, but I have filed this adverse.
Which paragraph?
My lords, para
3 onward.
page 2.
So have you filed any document in support of your contention that the petitioner was ailing at the relevant point of
I
time?
have not filed.
You have not filed?
No.
Sir,
How do you expect that?
when you came to know that it has been dismissed in 2022, what constrained you in not filing immediately thereafter? Why
Because
3 years again?
My lord, they have
2025.
filed on 22/9/25.
Oh, if you come to paragraph 3,
My lords.
you have said that the petitioner came to know in the year
The
2020.
petitioner is absolutely in default. But my humble prayer is, my lord, your lordship may any cost.
What cost?
Any amount
If
of
it was
cost,
within
because
your
it is
knowledge,
not
is it not your duty to explain the
kindly, my lord, your lordship will. State is not prejudiced because state did not